Letter from the governor, to the record, March 3rd, 2022, Executive Council, Chamber, State House, Boston, Mass. Dear councilors, I'm pleased to nominate Andrew Angelo to the position of Associate Justice of the Appeals Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm closing the nominee's resignation of convenience. Sincerely, Charles D. Baker, and the vice is the Honorable Diana Maldonado. I didn't know she was that. How long was she on the appeals court? Not that long.
10 years.
Yes, I voted for her. Okay. So, we will hear from your first witness, Chief Justice Paul Dawes.
May I sit here?
Yes.
Thank you. Thank you. Good morning. For the second time within approximately 1 month, I'm proud to appear before you to testify in support of the District Court Judge and his nomination to the Appeals Court. For the record, I apologize. For the record, my name is Paul Dawes. I'm the Chief Justice of the District Court. It's my privilege to testify this morning in support of Judge Andrew D'Angelo's nomination to become an Associate Justice of the Appeals Court. For over 16 years, I've worked closely in the District Court with him. He's not only my colleague and co-worker, but also a friend. I commend the Governor, the Lieutenant Governor, and the JNC for his appointment. In my opinion, and based on my experience working with him, he has strong writing and analytical skills. He has a deep intellectual curiosity about the law. He has substantial trial and appellate division experience and a demonstrated work ethic of hard work and dedication. All of these attributes, I respectfully submit, will enable him to be an excellent addition to the Appeals Court. His contributions to our court, the District Court, have been impactful. They've extended well beyond the courtroom. He serves as the chair of the District Court Technology Committee. Upon my request, he became the liaison to the Trial Court Information Technology Strategic Plan, a critical component of the future of the court system in trying to move and enhance the use of our technology. He's been an Associate Justice of the Civil Appellate Division, the Western District, a long-time and extremely valuable member of our District Court Criminal Committee, a member of the Case Flow Management Committee, and he serves as a mentor to other judges through our Judicial Mentor Program. He's also previously served as the Acting First Justice in Westboro District Court. In our court, he's viewed as an expert in drafting model jury instructions, and for many judges, he has served as a point person who provides guidance for complex legal issues. He's an experienced trial lawyer and trial judge, and he always is available to help newer and younger judges. Apart from his legal career and his legal abilities, I want to tell you what I've observed about him personally, because that frankly is more impressive than his professional career, and that is substantial. He's a dedicated husband and father. Most times when I speak to him, it's about our children. It's about the importance he places in the role of being a father and being a role model for his children. He's a loyal and steadfast friend. I've witnessed him to be generous, compassionate, and loyal. He's a very good listener and a very good colleague. I want to tell you just a brief story. Several years ago, we had a court in southeastern Massachusetts. And keep in mind, Judge D'Angelo was sitting in Worcester at the time. We had a court in southeastern Massachusetts that faced a significant backlog. We tried a couple of different ways to deal with it, and several of us came to the conclusion we just needed people who were going to be assigned there to frankly dig in day after day and work as hard as they could to hear these cases in a more efficient manner. And I asked around the state, can anyone help us out here? Judge D'Angelo is the first person to step up. And what it meant was that instead of a relatively short commute, he drove about an hour and a half each day for numerous months, day after day. The staff at the court loved him, the lawyers loved him, and the judges grew to have great respect because he selflessly put himself ahead of his own interest and put the interest of the system ahead. That's the type of colleague that I respectfully submit he'll be on the appeals court. I submit that his professional and personal attributes that I've described make him an exceptional nominee. He possesses superior legal abilities and personal characteristics to serve in the appeals court. I support his nomination. I respectfully ask you to confirm his nomination. And I thank you for allowing me the opportunity to be heard today.
Any questions for Judge Bell? Counselor from Watertown.
Thank you for coming. What an honor for this nominee for you to come. I'd like to, and I want to thank you for changing the schedule 3 times. This hearing has been changed so often, so I'm glad you could make it.
Thank you.
Glad you could make it. I just want to ask you wonderful things you said about him. Is there one attribute or an adjective that you could use to describe Judge Jubinville?
His generosity of time and friendship. To me, the thing that stands out the most is the way he's been a colleague. Very positive colleague. Especially on issues of law, he's always been available to research, to assist other judges dealing with issues, and for that reason, he's become a point person who can call him and seek advice on legal issues, particularly criminal legal issues.
Well, that's good. Thank you very much for coming.
Thank you.
I always enjoy your time.
Thank you.
Counselor,
Good to see you, Chief.
Good morning.
You're doing a great job. And I've asked you this question before. With cases surging, I saw NBC News, nightly news, I think it was the night before, Massachusetts is number 6 in the country on cases surging. If people come before you, whether it's a defense attorney, whoever comes before you, and has concerns about catching COVID, I'm going to make it easy. Is that an automatic continuance if they file a motion for a continuance and say, you know what, I don't feel comfortable, I haven't been vaccinated or I have been, it's just whatever reason.
It should be, the other point I'd make, Counselor, is the use of Zoom.
No, I understand.
I mean,
No, I understand that.
More and more.
I totally get that if it's a motion, but for a trial, you want to look at someone. You want to look at the jury. I'm sorry. I'm talking.
I agree. It's not reasonable to deny continuance with somebody dealing with the impact of COVID. That's my opinion.
Thank you very much. Appreciate it.
any other questions?
Good to see you, Judge.
You too, Counselor.
Let me ask you, Judge, how is the backlog now because of the pandemic?
Leave mine out of it. Leave my cases out of it.
I will say this, I'm really pleased at the district court level with the case law management. And I'll give you an example. When we look at, so we track the monthly numbers, and I can tell you, I think this past month, looking back a year, our case disposition rate exceeds 98%. We monitor monthly, and what you can see monthly is each court reducing the number of pending cases as juries are brought in and cases are resolved. The district court, I think, is in a different position than, for example, Superior Court. So Superior Court, when you're looking at complicated, multiple week trials, a lot of the same lawyers, that's going to take, I think, some substantial time to get through those cases. We have the benefit, obviously, of dealing 1- and 2-day trials. So I think I couldn't be happier with the way the courts have gone about to reduce the backlog. Because the bottom line is we know the longer these cases languish, it's not good for public safety, it's not good for a defendant to have to bear that over a period of time, it's not good for victims. So the quicker we can deal with them, and I think there's been really a unified process with clerks and judges working together to deal with this.
And is it the position of the district court that the Zoom phone conference will remain.
Yes. Yeah, we're in the process. Chief Justice Mark has asked us to implement by department standing orders, and I can tell you, based on feedback and discussions with a number of judges, our goal is to expand, now within constitutional confines. Obviously, as counsel said, a trial, obviously evidentiary hearings, it's important that you have an opportunity to confront the witnesses. But a lot of other case processing, hearing dates, I think Zoom is a significant and positive development.
I get the trial aspect of it, but on other matters like motions to suppress, dangerousness hearings, things like that, is that going to be on Zoom, or are we going to be able to have the witnesses in person?
So I think the presumption that for instance, a 58A hearing with confrontational rights implicated, I think the presumption is that would be in person, but the lawyer would have a right, if you have some circumstance and you're requesting it, you have a right to be heard to proceed to Zoom. The interesting thing is that the feedback from the bar, particularly on the civil side, is significantly in favor of more and more use of Zoom remote proceedings. On the criminal side, there's still some reluctance, and I hear this from CPTS, in terms of face-to-face confrontation, and so it's a little bit more split in terms of opinion on the criminal side than the civil side.
I had a dangerousness hearing on Zoom, and what I got out of it was, well, I was in person that day. The DA was in Zoom, police officer was on Zoom. And as I watched the police officer testify, I could see that he would be looking down and then talking and looking down. Clearly, he was reading a police report.
Yeah.
And the district attorney also would be speaking to the court, but then looking above him, above the camera. And he'd say, or they'd look back up. So he was clearly, somebody was behind him, either giving a signal or on a whiteboard or something, because he clearly was looking at somebody other than the camera every time he spoke. Which I pointed out to the judge, I didn't think that was fair, but that was at the start of the Zoom issue.
So it's interesting, as we have used it now, for the past 2 years, these issues have come up in terms of how to conduct it. I will tell you that the number one issue I continue to hear complaints about is the decorum and the clothing that some parties, or frankly the lack of clothing that people, there is some view that there's a lessening of the formality of proceedings, so I think we need to do a better job to maintain some decorum during these hearings.
Well, I'll just pick on us lawyers, but I have been on Zoom, and I have seen some lawyers, and I say, did you look in the mirror before you got on the Zoom? You got a t-shirt on, for God's sakes. But, yeah, and I know some judges say something like, at least look somewhat presentable. Come here, or something, you know. But I think a lot of that is faded out now. People seem to be getting the message on that part. So I'm glad we're going to keep it for certain hearings that don't require much, like recall conferences or CDs or those kind of things. It saves a lot of money around. But, well, I thank you for coming in, and your testimony means a lot.
Thank you. Thank you.
Kara Colby, Assistant Clerk Magistrate of the Fitchburg District Court.
Thank you. I'd like to say good morning, Chief Justice Dolly, to the chair of this hearing, good morning, Councilor Jubinville, from my own district, good morning, Councilor Capalla, and good morning to all the distinguished members of this council. It's a privilege for me to appear this morning before this honorable body in support of the nomination of Judge Andrew D'Angelo, who seeks your approval to become an appellate court judge. My name is Carol Colby. I'm an Assistant Clerk Magistrate in Fitchburg District Court. And prior to my position as an Assistant Clerk Magistrate, I was a solo practitioner practicing primarily in criminal defense in Worcester County for approximately 15 years. And I feel quite honored to be able to share some of my experiences with you this morning. Judge D'Angelo is not an ordinary judge. He is exceptional. He is exceedingly well versed in the law. In addition, he is fair, he is thorough, he is compassionate, and he is a gifted writer and educator. One could say he's a complete judge. Judge D'Angelo presides with a sense of professionalism and a level of expectation. He expects that lawyers who appear before him will be prepared for whatever they have on the docket that day. And similarly, he takes the bench each morning ready to work and ready to accomplish whatever comes before him. Judge D'Angelo has demonstrated a remarkable dedication to helping educate and encourage more inexperienced lawyers. The most apparent way is by his creating and implementing the Trial Skills and Practice Program in Worcester County. Starting out about 10 years ago as a skills class in Worcester County alone, this program has now grown into a collaborative effort and a statewide effort in the county. Judge D'Angelo has spent countless hours of his free time running this program, a true testament to his commitment to help lawyers become better advocates. Judge D'Angelo is an incredible teacher. He has a way of teaching from the bench that is not imposing or embarrassing for a lawyer. I've witnessed many times and experienced Judge D'Angelo citing specific cases or rules or statutes as the basis of his ruling from the bench. This is his polite way of nudging an inexperienced lawyer in the right direction. And he always makes time or is available to meet with any attorney after a motion hearing or a trial to provide valuable feedback, something that he's often taken up on by both prosecutors and defense counsel. Judge D'Angelo is always thoughtful and engaging from the bench. He has an uncanny ability to recognize issues. He is deliberate in his questions and in his responses, and he has a natural ability or way of encouraging debate, often when it's least expected. Judge D'Angelo is an asset to the attorneys practicing before him, both the well-seasoned and the inexperienced alike. His ability to dive into legal issues makes attorneys hopeful that he'll be the judge hearing their case. He's open-minded. He considers each case, not the parties. He's not personal. He focuses on the issues and the facts and decides each case according to the rule of law. And if in a rare moment an issue comes up that Judge D'Angelo is not well versed in or that he doesn't know off the top of his head, he's confident enough to know that he may not know. He's not shy about turning around on the bench to the law books behind him and finding the appropriate answer. This type of humility is not as common as you may think. Judge D'Angelo has demonstrated that he not only has expectations, but that he is also human. He listens well, and he understands when life gets in the way of a person's intentions or plans. Many times over the years, I have witnessed Judge D'Angelo make accommodations for lawyers who are dealing with issues in their personal lives, and he does so with empathy and with discretion. In the same way, I have represented many clients throughout the years who have expressed such gratitude for Judge D'Angelo, taking the time to listen to their circumstances and treating them with compassion. It's not uncommon for Judge D'Angelo to put a parent at ease if they're forced to appear in court with their child. He's always quick to explain that having 6 children of his own, he certainly understands the experience of a disruptive child. In making this explanation, the air truly is remarkable when a parent feels that level of relief. Judge D'Angelo has a deep understanding of the judiciary. He is well equipped to handle all legal issues that would arise in the appeals court. The entirety of his legal career has shown that he will meet this obligation with the necessary moral, legal, fair, and compassionate rule of law. By all reasonable standards, Judge D'Angelo is in the top tier of judges in the Commonwealth of Massachusetts. He would be a valuable asset, an excellent addition to the Massachusetts Court of Appeals, and I urge this council to approve his nomination.
That was very thoughtful and impactful. So, how long have you worked or have you seen the judge?
Well, I was a practicing attorney for about 15 years, practicing in front of Judge D'Angelo for probably about 13 years.
And you know, see all these letters?
Yes.
Every one of them, as you said, compassion. And I have always said publicly, I wouldn't vote for any big compassion in this case. And so that's now, I want to ask you, in all you've seen him all through the years, is there any one case that comes to mind that impressed you so much about?
I think the one thing that repeatedly comes to mind was a situation where when I was in my early days of practicing, and there was a prosecutor who was also fairly new. And the prosecutor inadvertently, or I shouldn't say inadvertently, dismissed the case believing that they didn't have a victim that was cooperating. And, or moved to dismiss the case, which Judge D'Angelo allowed. And that prosecutor, minutes after our case had been heard, realized there was some sort of miscommunication in their office, and she had moved to dismiss the wrong case. And the way that Judge D'Angelo handled the scenario from there, I thought was very compassionate and understanding that it was a new prosecutor. He very easily could have said, I've allowed the motion, that's it. And he didn't. He gave the prosecutor an opportunity to address the case and withdraw the motion in extreme circumstances.
And have you seen him after a case talk to lawyers and talk about it?
Yes, I think that's, in my experience and what I've seen, it's been pretty regular. A motion of evidentiary hearing or a trial, he always makes himself available to the attorneys, to listen feedback, to express his opinions about what he observed.
That's great. That helps him be a better attorney. Well, thank you. You're very valuable, your testimony. Thank you.
Thank you.
Any other questions? Let me just ask you, tell me about this program you mentioned, Trial Skills Program. Tell me about it.
Yes, so I was a participant a number of years ago. It takes, from what I remember, I think it takes up the better part of 2 or 3 months each spring. It starts as a sort of a training or skills class with both prosecutors and defense attorneys, preparing cases and presenting them on a weekly schedule in front of other judges or people that can observe them and give some feedback. And it's competitive in nature, so at the end of a couple of months each spring, the participants get to a level where they're presenting sort of a mock trial, and when there are votes as to the performances or the abilities of the participants, the winners of the program are then chosen to move on to compete against other counties throughout the state who are running similar programs in their counties.
And how does one get into the program?
I think it's voluntary, but you can, I believe prosecutors would be chosen through their office. Defense attorneys would be chosen through either the public defender's office or the bar advocate program, or maybe approached by, many.
Do they meet at night or on weekends? Or how do they do that?
All of the above. I think the sort of the performances or the trial skills part of it is evenings outside of work. But there are mentors in the program, so participants can be meeting with mentors, multiple times throughout the week in preparation for their trial skills portion, or whenever they have time. It's out, it's outside of work though, so it's your extracurricular.
How long have you been assistant clerk?
Just over 9 months.
And do you understand how important that job is in the court system?
I absolutely do.
that you get everything right on those docket sheets?
Yes.
Well, it's not a funny matter, because if you make a mistake, it's almost like, to try and change a docket sheet, it is extremely difficult.
It is.
So,
Yes, I
I
understand
see
that.
clerks sometimes that do it willy-nilly, and it's not a good thing, because that defendant may, for some reason, either spend more time in jail or not get off probation in time or whatever, and it's very important that every clerk make sure they get what a judge says. When I first started, they didn't have recording systems in the district court, but I guess the recording system could help out now to correct the situation, but, sometimes judges retire, they're unavailable, and there's a question about what's on the whole docket sheet, and you have to go back and try and figure out what went wrong.
I can tell you, Counselor, that from, practicing, I did primarily criminal defense work for my career as a practicing attorney, and I certainly understand the importance and the value of a correct docket sheet and docketing correctly, especially, like you said.
It's hard, because sometimes we have 20, 30 cases on for a day. You gotta keep either making notes or doing it as you go to get it right. So when I'm out in Fitchburg, I want to see whether you're doing that right. Sounds like you are.
I look forward to it.
Thank you. Where are the
Good morning.
Good morning.
I have a couple questions
Yes?
of this witness. So, I heard, I was delayed as a result of a traffic accident, not involving me, but thankfully. I heard what you said, so I was listening to it, and what would you think of a judge who put a lawyer in, or found him in contempt and held him because he explained that he couldn't go forward representing someone because of the breakdown in attorney-client relationship? Would you think that judge was pretty mean or awful?
Well, I can say that, I obviously understand what you're referencing and the scenario that you're referencing. I don't think that,
I'm sorry,
okay.
you understand what I'm referencing?
Yes,
And where were you at when that happened?
specifically, I was in the courthouse when that
And
happened.
what do you think of the person that was held in contempt by Judge D'Angelo?
Attorney John Gerard is a dear friend of mine, actually.
Do you
So
think he deserved that?
I wouldn't say he deserved it. I wouldn't take a position like that. I think most important to me is what Attorney Gerard's feelings are and how he responded to that situation.
Well, wait a minute. I understand that Attorney Gerard is one of the best guys you'd ever find. Kind,
I would agree.
considerate, forgiving. Is that correct?
I would agree, yes.
And his reputation was one of truthfulness, and he was considered a respected member of the bar. Is that correct?
Correct, yes.
And Judge D'Angelo found him in contempt for being honest about his inability to represent the client, which would have been malpractice if he'd gone forward. Isn't that true?
I don't know the details of the representation of that client. I mean, if you're saying that that's what he was saying, then yeah, I would believe that.
And therefore, he was acting appropriately and ethically as an attorney. Is that correct?
He could have been. Yeah, I wasn't in the room. I wasn't there for the hearing. I understand your questions, but I can't speak to those answers.
And is it fair to say that the entire Worcester Bar was up in arms over it? And very upset about it?
Yes, I think it's, I think it's certainly concerning as a defense attorney, when you hear that a fellow defense attorney has been put in custody by a judge. Yes, I would agree with that.
And is it fair to say Judge D'Angelo is very smart, but he also has to be the smartest person in the room?
I wouldn't agree with that, Counselor, I apologize, but
No, you don't have to apologize, I just want the truth. As you
I'm
see.
giving you the truth. I
Okay.
can't answer yes to that.
All right, if you were the judge in that case, would you have held that Attorney Gerard in contempt?
Again, I don't know what the hearing entailed, I don't know the details of it. I would guess I wouldn't, but I think that it's hard to say when
All
I
right,
wasn't the judge. What I can tell you, Counselor, is that Attorney Gerard is in full support of Judge D'Angelo's nomination to the appeals board.
and you wouldn't expect any less, would you, of Attorney Gerard?
I'm not sure what you mean by that.
You just told me that Attorney Gerard is a wonderful human being,
That's right,
all right? Well-respected, kind, thoughtful,
that's right.
and doesn't believe in doing unto others as they have been done to him. Is that a fair statement?
That's probably a fair statement.
Okay, thank you very much.
Thank you.
Can I ask you a question?
Please.
You were a criminal defense law chief?
Yes.
So if your client, in effect, fires you, can you then represent him?
Typically, I would say no.
Well, I would suggest not typically. Without any question, you cannot represent some client who has terminated your services. It's a violation of the Board of our Overseers, number one. And it's unethical, number two. And I understand the lawyer is a very nice fellow. He's in support of the judge. Personally, that does nothing for me. What else is he going to say? He's got to appear in Worcester courts before judges or other judges or Judge D'Angelo if he doesn't get this position he's going for, right?
Well, Counselor, I would just say that I agree with what you're saying, although in speaking with Attorney John Gerard, he did explain to me, and one of, I think, the biggest things for me personally as a friend of his that really set the tone for me in understanding how he felt about the situation is that he, very shortly after that incident occurred, I'm speaking within a week, was given the opportunity by the trial court to not have to ever appear before Judge D'Angelo again. And he, without hesitation then, and has reiterated now, that he, without hesitation, said no to that. He wanted to appear before Judge D'Angelo. His expression to me was that they had a great relationship prior to that incident. They have a great working relationship since that incident. He feels that Judge D'Angelo is a fair and a compassionate judge, regardless of what happened. And he feels that that singular incident is not something that should be an impediment to Judge D'Angelo being elevated to the appeals court.
Well, I appreciate his comments through you, but for members of this council, his opinion, his accepting of any kind of apology or his not wanting to be before him or be before him, personally, I don't think matters one bit. One bit. In your career, how many times have you heard of a judge locking up a lawyer?
I've certainly heard of it, and, during my practice, I have not seen it.
Okay, well, in my 44 years of practice, I think I have heard it done 3 other times before I heard about this incident. And each time, the judges that were involved in that, in one particular case, it was career-ending for me. You could ask place a judge, a lawyer in custody. Do you have any idea personally of what that can do to somebody to be placed in a cell or have handcuffs put on? You understand that?
I do, yes, I understand what you're saying.
I know an individual, a very high-ranking job in the court system, who was put into a jail cell in the Brighton District Court. To this day, and this was a long time ago, he has never gotten over being placed in that cell. It has haunted him ever since. Thank you.
Thank you.
Yes, Councilman.
I just want to make a couple of comments and pose a question to you. I've spoken a lot with Judge D'Angelo about this situation involving John Gerard. I've also spoken to John Gerard a lot, including last night. He actually texted me last night telling me that he was in support of this nomination. I respectfully disagree with Council Jubinville that that's not important. I think it is, but it's not the only factor that you look at. Because, it's a model sin in my eyes, locking up a lawyer, I don't know if it's going to keep him from going on the appeals court or not, but it's certainly about the worst thing that can happen. I've been practicing I'm in my 39th year. I've had many, many arguments with judges over the last 4 decades. Some of them pretty heated, and most of them will know when to stop. I think that, I'm going to leave it to Judge D'Angelo to explain it, but it's certainly, it's a big black mark on his career. There's no question about it, and it can only be described as inexcusable. Period. I cannot imagine, there's so many other options available to a judge other than locking the lawyer up. But I'll leave the questions to him. I just have to make that comment. But I did speak with John Gerard a number of times, and he did indicate that he was very supportive of this nomination. And I think that is a factor that we can make.
Thank you.
I really feel that you're in a very bad position talking about an issue that you're asking me your opinion of the judge, and I apologize for that. But now that they've discussed it, I think I should say as the only full-time counselor that I really do a lot of investigation, I think you all know that. Let's talk about what it was a woman who had gone before the court 2.5 years. She was representing herself, per se. She was harassing all the neighbors with yelling expletives, and even putting signs at her home with expletives. And the neighbors were concerned about their children seeing these expletives. So they went to court, and it was going on and on and on over 2 years. So now she got John Gerard, who is very respected, as a lawyer. And so Judge D'Angelo said, enough is enough. This has been going on 2.5 years. It's got to go to trial. So, Attorney Gerard, whatever he said, I can't talk to him. He objected, was upset, and that's how it happened. And when I spoke to Judge D'Angelo, and I met with him, I meet with everybody, and he said that, I'm sorry that event happened, but it was just going on so long that it deserved a trial. And that's what this was all about. John Gerard and the judge became friends. They worked together for years. They respect each other. And I don't think we should just pass it off, he has to support him because he's the judge. Not true. He didn't have to. And he has high regard to him. And it was an incident, they're both sorry that it had to happen. And he supports him 100%. And I think, in fairness, it should be said, because no one's saying what it was about, and I want to do that. So, that's a very sad thing to happen, and had to be embarrassing. But, it I think a judge has a right to say that. It's sad, but I don't think that it's a black mark against him at all. And both John Gerard and Judge D'Angelo are sorry for it. And I'm sorry that you had to be put in this position, because this was not what you should have been asked. You should have been asked what you know of him and what you observed, and not your opinion about things, about something like that. Because you can't give opinion on how he's ruled on cases, you know what I mean? So I'm very objective about things, and I'm forgiving. I forgive. You know, that's how I've been taught, that's how I've been brought up. And so both of them forgave each other. And so I really think it's an insult to John Gerard to say it doesn't matter. He has to say it. He has to support him. So I've said enough, but I thank you for your testimony. It was sincere in your friendship, and I know you're going to miss him. Thank you so much. Thank you.
Well, everybody has their opinion of the situation. I'm not apologizing, and I think the question is a fair question to be asked on the character of the judge. There's no apology needed here. You're a witness, you're a court official, you've practiced before the judge, you told us all that. So it's fair to ask you about that. What the person was charged with, whether it's jaywalking or murder, is not the point. It's not the point. It has nothing to do with the action of a judge. It is the worst thing, in my view, a judge can do. The worst. There is no excuse for it. It doesn't matter whether the case was on for 7 years. Once the person discharges a lawyer, you cannot represent him or her, period. And there's a lot of ways to handle things like that, like calling a lawyer into your chambers and expressing your opinion as to what's going on in private. And unfortunately for the judge, that will be brought up every time his name is mentioned in the legal community, from one end of the state to the other. Lawyers and DAs and clerks, we all talk about judges and about their personality and their temperament. And that's going to always, unfortunately, follow this judge. And we're going to hear from him about it. And hopefully he can convince this council about his feelings about it. So, to me, it's an issue that had to be brought up. And I personally think you handled it very well.
Thank you.
Okay, thank you. We're going to move on. Before you start, Judge, I just want to put on the record, we've gotten some letters here. I'm not going to read them because they'll go into the record. And so Judge Jim Stark sent a nice letter on your behalf. Peter Edinburgh, very fine, one of the finest lawyers in Worcester County, sent a letter on your behalf. Judge Eustace sent a letter on your behalf. I don't know, Nicole Longton, I don't know her. Sent a letter. Stuart Horowitz sent a letter. Cheryl R. O'Connell Riddle. So, with that said, they will go in your file and be on record. So, it is your chance to tell us what you want to tell us.
Thank you very much. Well, first, I'd like to thank everyone who was involved in my nomination to the appeals court, the governor, the lieutenant governor, their staff, the judicial nominating commission, Valerie McCarthy, who's been very helpful to me in putting all this together, and of course you counselors. I thank you for reviewing my application, my resume, and taking the time to do this hard work. I just want to take a few moments to talk about why I'm here and sort of how I got here. Because I know you know my professional experience in education. I have loved being a district court judge for 16 years and being part of the trial court community, not just as a judge, but part of that community. I have been frankly in awe of the employees of the trial court, whether it be the clerk's office, the probation, court officers, maintenance, everyone. The things they deal with on a daily basis of helping people when they are almost always in dire straits is truly remarkable. And I appreciate everything they've done, the support they've given me for 16 years as a district court judge, and frankly, during this nomination process, the outpouring of support from them has been truly remarkable. The lawyers that come before me, someone like Kara Colder, I appreciate all their hard work. I know it's not easy representing clients' interests all the time. I used to be there. And especially during the last 2 years, where court orders are changing almost on a daily basis, procedures. I know how difficult that was, and I truly am impressed with how all the lawyers managed that. What I have loved about being a district court judge is seeing the great arguments of lawyers during motion hearings, during trials, interacting with them during these legal arguments, because that's what I like to do. I like to read case law, apply it to the case before me, have interaction with lawyers, sometimes spirited, but always good-natured, always trying to get to the right decision. And after those types of hearings sometimes, I'm in a position to discuss things with my colleagues, my district court judges. And that is the part of me being a district court judge that I love the most. I really do. Having the ability to bounce things off to my colleagues and vice versa, and all my committee work on the criminal proceeding committee has just been wonderful. We don't always agree on a legal principle, but we have always, in the 16 years I've been a judge, been able to reach a decision on either the appellate division, jury instructions, forms, always been able to reach a consensus to put forth the best product we could. And frankly, it's that collaboration that's made me want to be an appeals court judge, because I love to do that. I love to hear from smarter people than me and their views. The district court judges are some of the most intelligent, hardworking, and well-meaning judges perhaps in the country, partly because of you folks. And I appreciate that. And I want to do that more. And I think I can do that more as an appeals court judge if I receive confirmation. How I got here is probably a little different than most. My dad came from Italy when he was 13 years old. He didn't speak any English. He knew 2 cents. Thank you. That's what he knew. So he started selling newspapers to help his family. He went on to selling blocks of ice, running a dry cleaning store, and selling souvenirs throughout the country. He ultimately, with my uncle, his twin brother, opened up the souvenir store across from Fenway. It's still there today. I started working at that store when I was 4 years old. And I had endless car rides with my dad. He told me about his life in Italy, the North End, and across this country. And one of the things that Kara Colby talked about, I think, was my kindness. My dad could not believe when he went across the country some of the things he saw. People being treated differently because of the color of their skin or their different ideas. He told me there were two things that were important. I'm sorry. Kindness and hard work. That's it. He said, if you're kind to people and you're a hard worker, you're a good person. It was that crystal clear, friend. And I won't forget the time in the store where a family came in, wanted a hat, Red Sox hat, of course, and they couldn't afford it. And my dad heard them say that. Now, this was when times were tough. My dad was working long, long hours. He heard that, and without a second thought, he reached back and gave them all hats and just said, "Go Red Sox." It's that kind of kindness and hard work and determination that I brought with me to being an attorney and a district court judge. As Kara said, I try to be the best judge I can be every day. I work hard, I study the law, I study each case that's going to come before me every day. Not because I want to be the smartest in the room, but because I want to do the right thing for everyone. That absolutely does not mean I get things right every day, because I don't. I make mistakes. I'm human. But when I make a mistake, and it happens, when I learn I made a mistake, I fix it. I say I'm sorry. I own up to it. And perhaps most importantly, I learn from it, so it won't happen again. That's what I learned. And that's what I would do if I'm lucky enough to get confirmed. Lastly, as you heard, I come from a large, immediate family. My wife, my 85-year-old mother, and my 6 children. And as you can imagine, having 6 children, a wife and a mother living under the same roof, there are some pretty spirited conversations, especially over the Sunday dinner, which we still try to have to this day. And I've learned so much from my children. And boy, are they ready to critique me on a daily basis, as is my mom. And I learn from them. They have different life experiences, things that I could never, ever read in a book, because they're personal. I've learned from 2 of them who are part of the LGBTQ community that how I say things, what I say, the pronouns I use, they all matter. It's the perspective of what comes before me on a daily basis that's important. And I know that. And I've tried to practice that, not only when I'm in front of the courtroom, but also on my committees that I'm on. In the appellate division, I bring those perspectives with me. And I think that is why I can be a good appeals court judge. I can bring the hard work, compassion that my dad taught me, and all of these different perspectives that my family has given me to the appeals court. And I promise you that if you confirm me, I will continue that hard work. I will continue to be compassionate. And I will continue to learn every single day to try to be an even better a better appeals court judge on a daily basis. And I thank you for your time, and I welcome any questions that the councilors may have for me.
Before we start asking questions, because of what's involved in the court system, we received a lot of, obviously, telephone calls about the elephant in the room that's already out. So Why don't you address that right from the start?
Sure. Counselor Devaney pretty much stated the facts the way they happened. Briefly to add, Attorney Gerard appropriately asked for many continuances before the trial date was set, all of which were granted without hesitation, because I knew he had to get up to speed. He was dealing with what was a difficult client. And then it came down to the trial date, finally, and there was a breakdown of communication. We had a hearing about that. Ultimately, what I did was wrong. I should not have done it. Legally, it was appropriate. But as you all know who are lawyers in this room, just because something is legally appropriate doesn't always make it right. And it was not right. I should not have done it. I should have availed myself of every possible avenue before I went down that road. And as the hearing was going on, I was thinking of all that, but I didn't stop enough to think about the feelings of the lawyer, of John Gerard, who I very much liked before the trial and have very much liked after the trial. Perhaps what I was thinking about was too much of the defendant who wanted to go to trial that day, the alleged victims, the prosecutor wanting to go to trial, and this being, as Councilor Devaney said, now going on 2.5, almost 3 years. What I should have considered more was how this would have impacted John Gerard. And even though I kept warning him during the hearing about the road we were going down, I shouldn't have gone down that road. I should have taken a detour. And once I did what I did, I took a recess. I can tell you that as it was happening, how sorry I was that it was happening. I went back into my chambers. I know there's a lot of rumors flying on about what went on. I can tell you I went into my chambers, I closed my door, I put my head down and thought about it more. I went back out, called him back in, rescinded the order of contempt, and moved on, and expunged it from the record. Expunged it. That was the only way I thought, again, knowing the mistake I had made, could try to solve it and help it and fix it. We met not long after the incident, certainly not that day, not because I was mad at him, but I just knew how emotional it was, and we met. And I said I was sorry to him. And I know, Councilor Jubinville, you're right, sorry doesn't fix it. I know that. And I know that will always be with me. It was the worst decision I ever made. And I hope I can come back from it.
Okay, so we have a procedure here that each counselor has 15 minutes to ask you questions. And any follow-up, 5 minutes after that. We'll start with Councilor Devaney.
Thank you for all the time you took with me. How long has it been now when you first came up for us?
About 16 years.
Wow. So, Counselor, I know, and we have to talk fast because they haven't taken a vote in the 15 minutes, so I'm sure that the federal judge, Jackson, they didn't cut her off at 15 minutes. But I do want to tell you, you will go down in history on the Governor's Council. You are the first ever to be limited in your hearing. You never limit the time, but you were limited an hour and 15 minutes. I think in 22 years I've never seen it. I don't know why. I don't understand it. The other thing is your hearing was rescheduled 3 times, and I thank the judge and you to come because they have to keep changing their schedules. And so it's been over a month, so you've been under a lot of pressure. I am you know, I don't dwell on that. I think, you know, Gerard knows, and you know, and we all know now. But unfortunately, rumors, and someone in this room said, she hates you, and all the judges hate you, and I see the most respected judge in the Commonwealth, yeah. So, but I just wanted to say that I can identify with you. My father was an Italian immigrant, came when he was 12. Well, made a mistake and he moved to Watertown when he was a young man. They didn't allow Italians to work. My father had to support himself, so he went to court and changed his name. And 30 years ago, I went to court. My dad's was on 56 years. 30 years ago, I went to court, and I got it for a middle name. So no one should take your name. But anyway, I want to ask you about some of the cases you had. I mean, how do you deal with mental issues, and you've dealt with people with alcohol? We don't hear alcohol, we hear drugs, but we don't hear about alcohol issues. How can you handle those?
I mean, most of the cases we deal with in the district court, frankly, are one of those three: a defendant with mental health issues, an alcohol problem, or a drug problem. That really is what we see on a daily basis. And how I handle those cases is to try to be as compassionate as possible to those defendants, try to help them with whatever problem they're having within the confines of what the crime was that they committed, making sure that the alleged victims, if it's a victim crime, are made whole. And again, to me, people who suffer from drug or alcohol addiction or mental health issues need to be helped more than they need to be locked up. Sometimes, ultimately, they have to be because nothing seems to work, but I'd like to say that 99% of the time, that is not the right solution. So I look for every possible alternative before that.
Well, I have been talking about drug centers, and they're not putting more out, they're not getting the funding, and I think we've got about 3, and I'm going to go to Framingham, and the men don't want to go to prison, Billerica, and that's a big issue. I've gone to the drug court, and I have to say I was very impressed in what they're doing, and I saw people of all ages, and it made me cry. I sat in the back, and really it was very emotional how people who were drug addicted or alcohol and came before them and said how the drug court and how, you know, the procedure they went through, and they graduated. It was a graduation. It was wonderful. So it's helping, but we still need more funding. I guess 1% that we're getting funding for judicial. So in the years, do you see that's increasing as far as drug cases or in your 16 years?
I think the drug case numbers are frankly about the same. What I've been seeing an increase over the last few years on more mental health issues. I think our society, we kind of know that mental health issues exist, but there's still maybe a stigma attached to it. And I think we all need to, including district court judges, superior court judges, appeals court judges, we need to understand their issues to try to help them more.
Well, some of them are violent, like happened in Brooklyn. And, you know, that's the thing. I can't even imagine how it's changed for you to be on the bench, you know. And I think you having 6 children really gives you a life experience that you bring, you know. I have 4, so I know. But, I love the background, you know, how your father and what you went through. When you got emotional, I cried too, so. But the thing is, you know, to think you still have that souvenir shop at Fenway Park, and what a wonderful thing that, you know, he pursued that. So, no, I understand how hard it was for you too. So, what do you see the change in going to the appeals court, and why did you decide to make that? I love it. I'd love to see someone 16 years as a judge to go to the appeals court, to bring that experience, you know? So tell us about that.
I think one of the things that drew me to want to apply was that some of my personal background stories and perspectives that I have are different than a lot of my colleagues. Not that any of them are wrong about anything, it's just it's a different perspective. And it's always good to me for people who are deciding cases, trying to apply the law to cases, to have these different perspectives to bounce off one another. So we can try to reach a decision that's not only applicable to the case and the law, but also to our different perspectives. And again, like I said in my statement, I have loved my collaboration with my colleagues, and I do it all the time. Not that it took away from today's hearing. I got a call this morning from somebody who was wanting to bounce something off me, didn't realize my hearing was today. But it's those kinds of interactions that I love to do. It's fun, it's great to hear other people's perspective. It changes my perspective sometimes. But I know that on the appeals court, I'm going to be surrounded on a daily basis, because that's what they do. Every single case that they read, every fact pattern that they read, has to be done by collaboration. You have to work with the 3 people that are on that panel. And I can't wait if I'm confirmed, because that's what I like to do. It's fun.
Yeah, no, is there any, in your career, is there one case you look back on and that it was, first of all, if I should say, these are all letters from judges, from people, and they all say how qualified, how kind, how fair, compassionate, and that's what I look for, and that's what I say. And you're bringing life experience. That's important to me, you know, and I love it. You live with your mother and your 6 kids and your wife. I mean, we don't see that. That's beautiful. But so you don't. So Lorraine, you love to write. I know that from reading, and so I'm going to run something by. Okay, this was at the appeals court, because I look into all these things, and there was a case at the appeals court, and when I met with you, I didn't tell you this at all. So there was a man walking 2 dogs. One was on a leash, and the German Shepherd was loose, and there was a woman on her lawn with a little dog, and the German Shepherd charged at this dog in the real time. She lived. She got into a bet. It cost her $4,000. She went to court, and the judge said that the dog is part of your household property. So he said $400. So she went to the appeals court. How would you have voted?
I will certainly have to look up the issues regarding property law. But to me, I think a dog is a member of a family to a degree. And I think the owner, as best she can, should be compensated for certainly the money that she put out to have the dog survive. And perhaps more than that, especially if the other dog owner knew about the dangerous proclivities of the violent dog, if I could call it. I think a lot more needed perhaps to be considered than just a homeowner's policy that gave the $400. At first blush, without, again, extensively studying the property law, that's probably where I would be thinking I'd have to go.
They voted to give her $4,000, and the dog was not property. And as an animal lover, I don't think they're property either, but I had to ask you. I'm not surprised, because, you know, you do have that the compassion. So what made you make the move now? You waited this long.
Again, I don't want this remotely to count against me, so to speak, but I like being a district court judge. I mean, again, I love the relationships. Yeah, I love interacting with people on a daily basis. So it's not that I want to leave the district court and go somewhere else, but I just thought it would be an intellectual challenge for me to do that in time.
I just wish I could read all these letters, because the things they said about you. But the thing that came to me was that was so important to me, that you really mentor the attorneys. And when the attorneys come to you after you talk to them about the case, and so they're learning. But you had such experience. You have worked with you know, Attorney Basil and all these wonderful things. Now, out of all of these positions that you've had, what do you think qualifies you or gives you more experience to go to the appeals court?
I think it's a combination. I think it's a combination of all the committee work and being on the appellate division. There are some committees on the district court that, although the judges work together as a committee, but there are some that you get sort of individual tasks, you get work done. On the committees that Judge Dolly and his predecessor have put me on, these committees really need to work together. As an example, it's coming up with jury instructions. We base our jury instructions on recent SJC and appeals court decisions. And sometimes, those courts don't come out and say, this is what the jury instruction should be, quote, end quote. They give sort of parameters, and we as trial court judges have to figure out what they meant. So the committee that I'm on, the criminal proceeding committee, we have, I think there are now 10 of us, we have potentially 10 different views about what the appeals court meant or what the SJC meant. And we're always able to come up with a collaborative effort and put together a jury instruction that not only judges can follow, but that jurors can follow and the lawyers can follow.
And I'm impressed with you spending nights and everything about the committee. Can you tell us what your experience on that?
I love teaching. I had some great, you mentioned Janice Basil. I was part of a fantastic law firm of Carney and Basil. And Jay Carney and Janice Basil were great instructors to me. And I didn't want to stop that when I became a judge. So after about 3-4 years of being on the bench, I saw that there needed to be more instruction on trial court matters. Because the lawyers are just so busy and their time is so limited, they don't have time to go to the NITA Atlanta course to learn how to try cases. It's not like in the old days when you could walk into court and see a quick bench trial and learn from lawyers who are better than you are. They just don't have the time to do that anymore. So I started a program where first it was just me of getting defense lawyers and prosecutors together to do a trial from beginning until the end. And I would ask other judges to come in and other prominent lawyers in the Worcester area to give critiques and help the lawyers. Then it developed after a new district attorney came in. He decided that he wanted to have mentors for his prosecutors. And CPCS and the bar advocate said, we'll get mentors. So it started to build and build and build, and ultimately, as Ms. Colby said, it became an internal competition in Worcester. And then I found out that at that time, I think he was still a West Roxbury judge. Judge Bob Kochka had sort of done the same thing in his area, and then when he became a Superior Court judge, he continued to do it. And he found out that I was doing it, I found out he was doing it, and we got together and we started this statewide competition that until COVID was going on all across the state. I think Chief Justice Dolly has presided over those final competitions a few times. And it's been a wonderful experience for the young lawyers who get to actually try a fake case in front of some great judges. And it gives the mentors the ability to have some teaching. And I love that.
No, I'm very impressed. I was impressed with you 16 years ago. I just think that you need someone that you had so much different types of. Why don't you go through, tell us all how you started and how you got here? It's amazing.
I started at the Suffolk County DA's office as an intern for, I think I ended up being there for about 6 years, started in high school, did it in college, did it in law school, ended up with the chief of the district courts, Jerry Malone, was able to start trying cases as a prosecutor, a student prosecutor, because I took evidence early at Suffolk, so I actually got to try a lot of cases as an intern. After that, I applied. Well, I actually wanted to continue to be a DA. A new DA came in, and I was talking to someone who knew Jay Carney. and Jay said that he wanted to meet with me before he recommended me to Ralph Martin. And after, it wasn't really an interview, it was just a conversation about what I wanted to do, he asked me if I would ever consider being a criminal defense lawyer. And I said, sure, I just love to try cases, I want to be out there. And ultimately, he and Janice offered me the job, and I was with the firm for almost 15 years. I was ultimately managing partner there, so I got to deal with the administrative things and tried cases in every court in the Commonwealth, District, Superior, Federal, and some cases across the country. And it was awesome.
Well, Janice, it's...
Thank you, Councilor Medina, your time is up.
So
Thank you for
I'm
your
in
minutes.
time, so they're gonna ring a bell now, so you're gonna...
Thank you, Councilor Ainello.
Thank you very much. Good to see you, Judge.
Let's see you, Councilor.
Judge, your 15 minutes or so presentation was very compelling. You talked about your father coming from Italy to America. It reminded me of my family. My father came to America when he was 8 years old with his sister and his mother. Couldn't speak a word of English. My father was a very fortunate person. He went on to go to Boston College and the Harvard Law School, and then after that he had 40 years of public service. But he was extremely hardworking, like your father, and he was very compassionate. And those are two qualities that are so important. So I like that part. You know, your whole presentation was excellent, but there was one little sentence, and I went like, what? And I wrote it down. It's the only thing I wrote down. Well, again, we're talking about, I don't even know the gentleman's name, and you go, legally, it was appropriate. That to me is like, again, maybe I'm missing something. It's almost like, well, yeah, I could have done it, but, so tell me what you meant when you said legally, what you did was appropriate.
Appropriate meant that was a legal option.
To throw someone in jail?
Legally, again...
So, see if I have it right, I didn't mean to interrupt you.
No, go.
So, if somebody is discharged, fired, okay? Someone is discharged, the client discharges, fires the attorney, and the judge says, hey, you gotta start the trial. The attorney says, oh, I can't, I've been discharged, I don't want to get reprimanded by the bar, by the Board of Bar Overseers. It's basically, you're saying, I mean, to me, you're saying that maybe he should have. It's okay, so if he shouldn't, what's appropriate about the fact, well, let me even backtrack it, sorry. Did he have a right to represent the guy once he's fired, or once he was fired by the woman and discharged? Did he have a legal right? Could he have represented her?
Not if he had been fired by the client. The client, the client had not fired him.
Okay, because that was my understanding.
What happened was, and again, I have to emphasize, when I use the word appropriate, what I mean by that is legally a judge can hold a lawyer in contempt. That's the only part of appropriate I mean. It is not the course of action that I should have taken. It's not the course of action that any judge should take. But the facts, just the day before the trial or 2 days before, the lawyer came to me and with the prosecutor and said, I'm having trouble with my client. She wants me to call certain witnesses that I don't want to call. And I said to him, very candidly, on the record with the prosecutor, if she doesn't want you to represent her on Monday and she's willing to go forward, I will discharge you in a second. But this trial has to go forward because it's been almost 3 years. And he said, I understand that, Judge, and I'm ready to go if it comes to that. I said, okay, just so we're clear, if she wants to represent herself and not have you, that'll be ready to go. And on the trial date, he filed a motion to withdraw. I can't remember whether it was in writing or orally. but I said to the defendant, do you want him as your lawyer? And she said, well, he won't call witnesses that I think he should call. I went through a colloquy with her and explained to her that it's the lawyer's job to decide what witnesses to call and so forth and so on. At that point, she said, I didn't know that. I thought it was my choice. And I'm happy with Attorney Gerard, if that's the rule. And I said, again, I'm 100% sure of this. I said, are you sure that you're content with his representation? And she said, yes, I am.
Okay. So
And
you,
then it went to Attorney Gerard, and that's where he refused, and I kept saying, I understand your objection. Your objection is overruled. She's content with you. You're ready to go to trial. But again, please let me emphasize, there are other things I could have done before I went down that road, and I should have.
okay, so, again, I didn't know much about this case. So it's your position, and I guess I thought differently, to be totally honest with you, that Attorney Gerard was fired. And Attorney Gerard told the court, I can't represent so-and-so because I got fired. But it's you're telling me, though, I have the facts wrong.
It was slightly different, yes.
Well,
It
was he fired
No.
or was he not?
He was not fired.
Okay. Okay. Yeah,
Now, I will say, Attorney Gerard, and I know I was in this position as a defense lawyer, and I'm sure other people here have been in this position. He was not happy, obviously, with the fact that the defendant had expressed an interest that she didn't want him as a lawyer. And his concern was real, that he was afraid that if she went to trial with him and she was convicted, that of course she would go after him in front of the BPO. And I acknowledge that concern, and perhaps that's probably or definitely where I went.
so it's your statement today that best of your recollection, Attorney Gerard was never fired by the defendant.
No.
Okay. Well, I appreciate that because
I understand.
I didn't realize that. I know of someone about 42 years ago who was at the BMC jury session, and that individual had 3 cases on that day. One at the BMC, one in Roxbury, and one in West Roxbury, and all at the same time. And they were 3 court-appointed cases. We don't have the system now. At that point, the judge would appoint you. And both cases were on the same time. And maybe the lawyer should have called or should have made contact with all the courts saying that he was going to be late. So what happened was that lawyer appeared at the BMC jury session. And the judge said, Attorney so-and-so, you're late, and you should have been here at 9 o'clock or 9:15. I'm going to throw you in the dock unless you pay a $100 fine forthwith. And you know what? That lawyer didn't have $100 in his pocket. So that lawyer had to walk across the street, saw his father at City Hall, and he got $100. And that lawyer was me. The judge later apologized to me, and I never made a big deal out of it, but, I never went in the dock. Luckily, my father was around. I had that $100. But you could say maybe I should have called, got in contact, and I get that. But putting a lawyer in the dock, that's a little too severe in my mind.
No, it's a lot too severe, Counselor.
Yeah.
It's a lot too severe.
But having said that, I am familiar with your family, as is my brother. As you know, my brother works at Fenway Park also, and he speaks highly of, I think it's your brother?
My cousin.
Your cousin, Arthur. But yeah, no, I'm glad at least in my mind, resolve that issue. I just have one question. The Sons and Daughters of Italy Justice Award, what is that?
It's an award given to people in the legal community who have showed compassion. I think usually have, maybe always have some type of Italian ancestry. And that committee looks at qualifications, looks at what that person's legal career is, and feels that that person is someone who represents Italian Americans in a good way, and I was lucky enough to win that award.
Councilor Jubinville, I was on that committee, can I just tell him?
No,
Thank
no.
you. I know, Kevin,
Oh, he's the chairman. No, excuse me. I don't have any further questions.
Councilor Duff.
Thank you, Mr. Chairman. Mr. Chairman,
Excuse me. Councilor Duff.
thank you. Lost a little bit of my train of thought. This is, I know I don't want to keep beating a dead horse. This is a very, very, very serious issue. And the way you answered that question in that statement, I mean, I was just like, you gotta be kidding me. And I know your explanation, and I get it, but I'm really struggling with it, I'll be honest. And there are a couple of things. You're a smart guy, and we know that, right? And my family came from Italy, and we were all Italian, and that's great, but that doesn't mean we put you on the bench just because we have this common heritage. But, and I don't want to, I always try not to, I don't want to be embarrassing, but people say you're very arrogant, that you're very, very smart. And that statement in and of itself was almost a reflection of everything that I hear. I hear two different things about you. I hear everyone says you're smart. But people say 6 years ago he was at a judges conference telling everyone he was going to get promoted to the appeals court because Baker was governor. Disturbing, and I heard that from more than one person. I'm not asking you to answer this. I'm just speaking right now. Also, I'm not sure the district court is suited for your personality. And maybe the appeals court is a better thing for you, for your intellect and the way you work, because they're very, very different. Yet, there are people who work in the appellate world who have expressed concern that you may not be able to play well with others because you've got to be the smartest guy in the room. And so if you are elevated to the court, I want you to keep that in mind to sit back and be quiet and listen and learn. And I'm sure you will, because you're a smart man. As everyone in this chamber knows, I can run hot and I can shoot from the hip, and I've said things I wish I hadn't said, and I've stepped in it, and we all have. We're human. And that is also where, we try to be forgiving, right? And that means a lot to me. And you being contrite means a lot to me. I also have somebody who's important to me that was denied a judgeship because of something far less severe that he did, because he didn't have the right political connections. This guy's one of your biggest supporters. He shouldn't be. I don't even know if you know him. But I don't think you do know him, but he's followed this. And his opinion means a lot to me because he was denied. He was denied something that he deserved because certain people in certain positions didn't like him, personal reasons. You're hard for me. I'll be really honest. You're brilliant. You remind me a little bit of Scalia, frankly. And Scalia was a different philosophy than me, but a brilliant jurist, right? I don't think anyone who read any of his work can deny that, right? Brilliant jurist. Maybe just you look, the Italian. But I'm gonna talk to you again. Honestly, I don't want to rehash this right here because it's just, there's no point of banging you over the head. Because I need to do some deeper work on this, and I'm going to do it with you.
Okay. Counselor, can I?
Absolutely, you may.
I respect all the questions and comments.
And I'm sorry, because I know I just barraged you.
Please, that's okay. That's why I'm here. one of the things that you said that I don't want to say bothers but concerns me is that there is a concern out there that I guess I can't play well with others, to put it in playground terms.
Right.
I can tell you until I'm blue in the face that that's not true. I would urge you, I can give you the list of all of the judges that I have worked with. Forget about judges that I have a passing knowledge of.
Correct.
They don't know me. But the committee members that, again, these committees, the ones I'm on, we work together daily.
And
Yes.
I know you hear appeals with the district court. I know you're involved in that. And that, I don't want to say gives me solace, but that gives me some, and I have great respect for Judge Stawley. But I would be remiss not to tell you, and I don't say it to embarrass you, and I don't say it to be demeaning. I say it because if you are elevated to this court or moved to this court, I don't know if it's a promotion or not, but you really need to understand that there are people in that world that will be concerned. You're going to have to be better than you've ever been in things like our own internal work that we have to do when we do something wrong, to say, I screwed up, I'm sorry. And you've done that today, and I understand it. I still struggle with that a little bit, but that be said, there's no point of just banging it over the head. It's ridiculous, to me, we all get it.
And I look forward to talking to you after.
Absolutely, and I apologize, as some people may know, I had another death in my family last week, and I was really unavailable because I was all over the world dealing stuff, so I'm so sorry. But thank you for your time. Thank you for being here, and frankly, thank you for the application, because I think it's important, and I know that you knew that when you applied, this would come up. And I think some of the attorneys have brought up, I'm not in the courtroom. I look at this from a different point of view. I always say I worked with some of the best attorneys in the world when I worked in Washington. I mean, these people were brilliant, and they taught me what I knew and what I didn't know. Never misrepresent yourself, and yada, yada, yada. But what happened was a difficult thing, because that attorney that will be with them forever.
Yes.
It just is. It's a brand. So anyway, thank you, Mr. Chairman. I appreciate your time.
Thank
For giving me the time.
You were hitting a home run when you were giving your statement, until you said the terms legally appropriate. And I think everybody in this room cringed when you said that. Because, you're a pretty smart guy, and you obviously thought a lot about what you were going to say today. Fair to say?
Yes.
Okay. And we stepped out and talked about it. Like, what was that? Where did that come from? I cringed. I couldn't believe you said it. For somebody who was smart as you are, who thought as much about what you were going to say, who realizes, I believe, what a terrible mistake you made, why'd you qualify it?
I didn't mean for those words even remotely to be that they were qualifying. I did not mean that.
Well, that's the way it came across to everybody, that you were qualifying what you did, that,
No.
yeah, maybe I shouldn't have done it, but it was okay.
No.
That's what it sounded like.
And if that's the way it came across,
That's the way it came across to, I think, everybody in this room.
I will say it a million times and mean it every time. It was not okay.
Yeah.
It was the wrong thing to do.
And you-
I shouldn't have done it.
How many times have you and I had a conversation about exactly that?
Yes.
About exactly not qualifying what you're
Yes.
saying?
Yes.
That my expectation was
It's not
total
qualified.
acceptance of responsibility.
I did not for a second mean those words to be qualifying in any way. I will say it again. What I did was wrong. I shouldn't have done it. I will never, ever do that again. And the words legally appropriate was a slip of the tongue that in no way.
But
is
you're not
what
the
I
guy
meant.
that makes slips at the
Oh,
time.
I do.
You thought a lot about what you were going to say when you came in here today.
Councilor Kennedy, if
And we talked about
And
it
this
more
is-
than once.
This is why I hope you understand, you especially, because we've talked about it so much, that it was a slip of wordage, because I know how wrong it was. I've made it clear I know how wrong it was. And I did not mean to imply by using those words that it was appropriate in any way whatsoever. It was wrong. I know that. And as Councilor Jubinville pointed out in one of his questions, it's a black mark. And I haven't been able to hide from it. I know it's out there.
I want to talk about a little bit about your relationship with all your colleagues, okay?
Sure.
And some of the stuff that's going on there, all right? We had a Superior Court nominee a number of years ago, Deval Patrick, where I think he's on the Superior Court now. He was chair of the parole board prior to that. We had 100 people in the room, half of whom were testifying against him, okay? There were lawyers that I have a lot of respect for, like Rosemary Scapaccio. I think Willie Davis came and testified against him, he was one of my heroes. And a lot of people that even that he worked with previously come and testified against him. And he's a very good judge now, okay? Everybody likes him, but he was totally floored by that. It was a 3-day hearing, didn't get over in one day. He was totally floored by that. He had absolutely no self-awareness that there were these people out there that didn't like him, okay? That thought he was arrogant, which is kind of like the same message that we get about you a little bit, okay? I've gotten a lot of calls about you, not just recently, but in the past, okay? I've appeared in front of you twice, okay? Twice. I remember them both. Once was 10 years ago, so it was out in Worcester. We had a little tit for tat because I got tied up in Superior Court. You yelled at me, I yelled at you, and I went on my way. I didn't really care. The second time was when you were in Concord one time. I did a bench trial. It was a not guilty. I was pretty happy that day, okay? So I haven't had a lot of experience with you, as I have with most of the judges, in district court especially. Most of them know me. I've tried cases in front of most of them. But I got a lot of calls from some of your colleagues that were very, very favorable. My classmate Julie Bernard called me. She told me how when she was buried down in Brockton, that you went down and helped her out. A number of judges absolutely called me in support of you, talked about how smart you are, talked about how helpful you are, talked about what a great colleague you are. But I also got something that I usually don't get. I got some calls from your colleagues that talked about you being arrogant. And I'm not going to name them, okay? But at least 3 or 4 that talked about that. And that was somewhat troubling because that doesn't usually happen. First of all, it's very rare that we get negative calls about anybody, frankly. Sometimes we do, but it's extremely rare. But there were some of your colleagues that called me that I know, that I've tried in front of. Some I know well, some I don't. And it wasn't just 1 or 2 that talked about, you being the smartest person in the room. Now, I got 2 questions for you with respect to that. One is, why do you think that is? And number 2, if there are some of your colleagues that don't like you, why is it that you're not aware of that? Why don't you have the self-awareness to realize that, hey, maybe I could use a little more humility in terms of dealing with my colleagues?
I'll address the first part. Why it is, I don't know. All I can say is that I speak at a lot of conferences at the request of Judge Dolly. Sometimes I do try to put a lot of humor.
Let me just say something. There's not one person that I spoke with, and I spoke to a lot of them, that didn't say you were really smart. Everybody agreed that you are a really, really intelligent guy, which is why I find your statement a little troubling, because you're smart enough not to say that, but go ahead.
I guess I don't frankly like that you're all calling me really smart. I'm not.
No, you are, but that's...
I'm just prepared. I read everything that I can. Perhaps because when I'm asked to speak at these conferences or somebody calls me for a question, I cite a case and I say, take a look at this. maybe this has the answer. Maybe that comes across that way. Sometimes, again, in my teaching mode, when I'm doing a conference, whether it be for MCLE or for other judges, perhaps when I try to impart humor, because I think that's part of being a good teacher, is not just droning on and on. Perhaps some of my humor is taken that way. Counselor, it would be ridiculous for me to think that out of 162 district court judges that I've had over the years, that every single one of them thinks I'm the bee's knees. I know that's not true.
Well, but I know that, but it's a step further than that. I know that there are judges that like each other and dislike each other, annoyed with each other, and annoyed with each other. When Judge Brennan got elevated, I congratulated him on not being the principal of the middle school anymore. And he started laughing. He said, "You wouldn't believe it. I could tell you stories." So I get that part. But this goes beyond that, because they picked up the phone.
Yes, I'm obviously I'm hurt by that. If I could change something, I wish they would all love me. I wish that were true, but obviously, of course I believe everything you're saying. I can't explain why or who or what the episode or episodes that caused that. I can tell you that if any single one of them had approached me, and I know that's obviously probably crazy, but said, "Hey, that came across X, Y, and Z," I can't imagine I meant it to come across that way. And I would have fixed it.
People aren't going to come up and call you arrogant.
Right, exactly.
Okay?
But if they
Well,
say,
you
"Hey,"
came up as really arrogant in that lecture you gave. That's not going to happen,
no.
you know?
But what I mean is, if I said something
Let me
in
ask you
an
this.
inappropriate way, I would have fixed it.
Let me back up. You talk about feedback, okay? And I'm going to run out of time in a minute. So, you've been around a while, longer than I've been here 12 years, and I didn't vote on you the first time. So you've been around a while. So you've been around, how many, 16?
60.
Okay. They had a judicial evaluations, right, back then?
Yes.
How did you do on those? What was the feedback you got from those?
Pretty good.
Okay,
I mean,
okay. You know, I talked to a judge recently about them. They don't have them because they did away with them because there was issues to whether there was some bias in them against certain types of judges. And I think that's a shame because I think some judges altered their behavior based on the feedback that they got.
well,
You had to get some negative
I'm
feedback.
sure. And I think, to me, reading those evaluations, when somebody says something even slightly negative, it's self-reflection, and I look at it and say, maybe I did come across that way, I need to change that. And all I'll say is regarding the evaluations, Judge Dawley and his predecessor asked me to mentor new judges and
Okay.
judges that have issues. They get my evaluations. They're the only ones, frankly, who read them other than me by the statute or whatever the protocol is. I don't believe either one of them would have asked me to do that if they thought there was an issue.
One of the things, though, that other judge said to me, who's now a judge, after his hearings, 3 days worth of hearings, and he got beat up. Everybody knows what I'm talking about that was here. He got beat up pretty bad. People were sitting down next to him saying, "Don't vote for this guy, he's no good. Okay, he's arrogant, he's this, he's that." And I think it says a lot that there aren't people here testifying against you, by the way, like they were with him. But one of the things he said is, "I really have to think about that. I've never thought about that. I've never realized that." And I think he really did reflect on that. And I think he did alter the way he handled things when he got into the Superior Court, to be aware of it when he's on the bench, that sometimes he comes across like that. Okay? I mean, we all have personalities, you know. People think I'm a little bit of a arrogant sometimes too. No question about it, all right? I come off that way. A little cocky, I guess is a better word. It's how I would come off.
That's a good one.
Huh? Yeah, it's my personality, and I get that, okay? And I get that your personality might be that you come off as being a little arrogant. It doesn't necessarily mean you are. I'm just gonna circle back to that case involving John Gerard. And John Gerard, I didn't seek him out. He called me about something completely unrelated to this. And of course, I brought this up the first time I talked to him. And unsolicited, he texted me last night to tell me that he was fully supporting your nomination, okay? And I want to be clear about that. But you said something that really bothered me a few minutes ago when I answered the question about, well, the case is 3 years old, it has to go. Why?
Okay.
What, if it went a month later, what difference would it make in the world?
Well, again, if it was just a case that was making its way through the system, I agree. One month, 2 month, 3 month, 4 month, that happens every day, as you know. This was a situation.
Right now, I'm trying 2018-19 cases because of the
Exactly.
pandemic.
But this was a situation where, again, for whatever reason, the defendant was representing herself first pro se.
Right.
Nobody had asked
I
her.
understand, we talked about
Yeah,
the case, and as I understand it, later on, it was resolved by way of pretrial probation.
Yeah, that's the end result. And I'm not
Right,
even
but
talking-
that also tells me that it's not that big a deal.
Right. It was obviously a big deal to the people involved, and that's probably...
But when you resolve a case in district court by way of pretrial probation,
Yeah.
it just strikes me as that it just wouldn't have mattered if it waited a month,
If I thought it had just been...
or even 2 months.
A few months probably wouldn't have been a big deal, you're right. Bless you.
That's just my view, you know? I may have I may have a little bit of a reputation of my cases last a little longer than most. As Judge Dolly would point out, when they had the matrices, I used to skew them a little bit because I'm busy. Not because I'm intentionally delaying
Sure.
cases, I'm busy.
Yeah.
So I'm in front of you on a case that's 3 years old, and I say, Judge, I need a couple of more months. What difference does it make?
Counselor Kennedy, if that had been the situation, it would have been granted.
But that was,
If you need-
but that was
if you
part
need-
of it. Gerard wanted out because he had a problem with the con, probably worried about a BBO complaint coming, okay?
Yes.
You know, and he had an issue, with the client at that point had an issue with him, and I understand there were probably some mental health issues involved in the case and things like
No
that,
question.
which is all the more reason to let it slide a little bit more, okay? But if he's there and he's saying, I can't do this, for whatever reason, what difference does it make? The world's not going to collapse because this case gets 3 more months, 4 more months on it.
You're right.
And what I've seen judges do a lot when there's a breakdown, there was clearly, you would agree with me, there was a breakdown in the relationship.
At that point, yes.
Okay, so if there's a breakdown in the relationship, whether she says, I want him as my lawyer or not, he really can't effectively represent her, right?
Yes.
Right. So if that breakdown in relationship leads to that point, I've seen judges say, okay, Mr. Gerard's not your lawyer. Are you prepared to try the case yourself? I've seen that a lot.
And that's frankly where the colloquy started, Counselor Kennedy, with that defendant was, I heard there was a breakdown. We went through the breakdown about witnesses, and I said, are you ready to try the case yourself? And she said no, and we went further down the road. And I said, what's your problem with Attorney Gerard? And that's where it was. Well, he doesn't want to call certain witnesses. And I guess, and again, I should have granted the continuance and got her a new lawyer. But the problem, I guess, as a judge that it was facing me was, the defendant wanted to go to trial and was ready. The alleged victims wanted to go to trial. The prosecutor wanted to go to trial, and this was the thing that was the most difficult.
But
Attorney Gerard said he was prepared.
My time up?
He was
My-
prepared.
Okay. My time's up, so, I
I should
appreciate
have
you.
granted the
Thank you.
Thank you, Mr.
What did I
Chairman.
do?
Mr. Chair, if I come closer, could you give me a 3-minute warning?
Yes.
Good afternoon.
Good afternoon,
Or-
Counselor.
Good morning.
Still good morning.
Good morning. Do you know who Chris Rock and Will Smith are?
Yes.
So earlier, I don't know when it was, last few weeks, right? Chris Rock is telling jokes at an award ceremony. Will Smith took issue, walked up and slapped him in the face.
Yes, sir.
Puts Chris Rock in a tough spot, PR-wise, right? What's he supposed to do? So I've heard him, I don't follow pop culture very much on this level, but I've heard people say, oh, he's keeping quiet, and he said he's accepting, what else is he going to do though, really? Have you had occasion in district court to deal with domestic abuse?
Of course.
And so how do you evaluate when the victim or alleged victim of domestic abuse comes in and supports the alleged abuser in some way?
I try, through my questioning of that, and I'll call it a victim because you're saying there was violence, to ensure that the victim is doing things of her own free will, that she understands the circumstances of what she's asking me to do, whether it be to stop a restraining order, to dismiss a case. I make sure that she understands all the possible ramifications, and if the answer is she does understand all those ramifications, then ultimately I probably do what she wants, because
So
I
I know
don't
I'm
want to
speak-
re-victimize.
I know I'm speaking in broad hypotheticals here because it could apply to various situations as you state, but how would you determine that? What kind of probing do you want to do to make sure that you have an understanding of it?
Sure. Ideally, if the victim has an attorney, I want to make sure that the attorney has spoken at length to the person about what he or she is doing. Usually that's not the case in the situations you're describing. I try to ensure that there's been no undue influence by asking her have you had any communication with Johnny Defendant? Has any family members talked to you about Johnny Defendant? Are you under any financial constraints that make you that you need Johnny Defendant, and that's why you're doing this?
So
Again, I just try to make sure that she's doing this for a reason that's not just because she feels she has to do it.
So I'm understanding and appreciating that your perspective on that. So I appreciate that. The thing about the issue that's been talked about today, it's not the thing that most bothers me, but Attorney Gerard, this is on him now for his career, right? I heard about this when I was elected to council, before I was seated, that your nomination was coming up. I was receiving phone calls that you were possibly being nominated to field somewhere. Possibly.
Okay.
I mean, I was getting those phone calls immediately after election day from people. Some pro and some con. And no attorney in their right mind is going to go on record as being opposed to a district court judge's nomination to another seat, in my mind. So I'm cautious when evaluating what folks have to say about it. At the same time, I believe in second chances. Some people think I believe in them too much. So I don't think one moment should be held against someone forever and ever. Some attorneys in the Worcester Bar community who I speak with complain to me that the process is too political. Do you think that's true? Have you ever heard such complaints?
Yes.
What kinds of factors do you think lead to those complaints? Or has anyone ever expressed to you why they had that sentiment?
Absolutely. I think there are people who are very qualified to become judges. They seem to have many years' experience. They seem to do fantastic jobs. Some of them apply to the Judicial Nominating Commission, and they get rejected either prior to an interview or after an interview, and they don't understand why. Sometimes I get calls after that saying, do you have any explanation? And of course my answer is no, I don't understand it. But I also know that people's applications don't say everything. And perhaps maybe when the JNC or this body does due diligence, they learn of things that aren't evident on the papers, which clearly you folks have done.
Do you think that political considerations or personal connections are ever one of the factors that leads to an outcome? Among a number of considerations?
I guess if you mean by personal connections, I'm a friend with X and he's a friend with Judge D'Angelo, so I'm going to vote for him. No, that I don't think is appropriate. On the other hand, if a friend of Counselor Duff reaches out to her and says, I know Andy D'Angelo, I know him as a judge, I'm on committees with him, or I'm a lawyer that's appeared before him 1,000 times, and I think he would make a great appeals court judge, let me tell you why. I think that's appropriate. I think that's what you folks should do, or else you're trying to base a decision strictly on the black and white that's in that application, and as I already said, somebody is more than what's on an application.
Absolutely. Have you ever heard of or known of attorneys being under diligence by JNC?
Yes.
Would you say that when an attorney is under diligence, that by and large the legal community knows about it?
I think that's a fair statement, yes.
I think that's a fair statement too. So I don't think it would be disqualifying. So I'm not concerned. It sounds like maybe I misquoted or you didn't say that you were applying to or hoping to be on the appeals court as early as I implied or that I've heard. But I don't think it's disqualifying if you did. I don't see why it'd be a problem. Are you familiar with Commonwealth versus Ubani? It came out of juvenile court. A judge in juvenile court held an adolescent in contempt for cursing the judge out. And the Supreme Judicial Court ultimately underturned that. Are you familiar with that by any chance?
I recognize the facts, not the name.
Sure. So, in that case, and in other cases, and I won't get into the minutiae, but just to kind of offer broad strokes of the SJC's thoughts, in their decision on Ulani, they recognize that juvenile justice is primarily rehabilitative, cognizant of the inherent differences between juvenile and adult offenders, and geared towards the correction of redemption society. What do you think is the difference between juvenile and adult offenders?
The juvenile system is based almost exclusively and primarily on rehabilitative purposes. I think the district court and superior court, although that's a major component, and I think it should be even more of a component, it's more than that. The juvenile court is a place where juveniles who make mistakes should be able to figure out what mistake they made.
Why do we allow that? Why is it a public policy that we allow that? Or that's our strategy in juvenile?
Sure, sorry. I think it's twofold. One, which you just stated a few minutes ago, which is everybody must make mistakes and they should learn from it. I think that's one. And I think the second thing is, as more body of work comes out about medical things, that a person's brain does not fully develop until they're about 25 years old, and their brains are still developing and they don't know.
And sure, and the Supreme Judicial Court has pointed to current scientific research on adolescent brain development, myriad significant ways that the development impacts a juvenile's personality and behavior. But I could subwords impacts a young adult's personality and behavior, couldn't I? So as a district court judge, how did you strike that? As a district court judge, did you take into consideration an alleged offender's age or development status?
Yes.
And so are you aware that when someone suffered significant childhood abuse and trauma, that the development that we know goes on into the early 20s is actually exacerbated and delayed?
Yes.
And so how do you take that factor into consideration when you have occasion to exercise discretion?
Sure. I will tell you that one of the things I greatly instruct the lawyers when I have these programs, this committee, is I need to learn about those kinds of things from the defense lawyer, to not only look at the facts of the case, but their background, so I know about that. That's the first step, that I know about it. I take it into consideration by, again, as I think I mentioned to Councilor Devaney, the most important thing for me is trying to make sure that somebody can be rehabilitated.
What do you think the likelihood is that a defendant would reveal their childhood abuse to the court or to their attorney? I think it's a high likelihood?
I'd say moderate. I hate to sound like a lawyer answer.
It's hard to pin it, right?
I think it probably depends on the defense, usually the criminal defense lawyer, to bring that out of someone or to learn about it from family members, and that's important.
Now, in the Ulani case, the court was able to settle on the issue of contempt and didn't get to the discussion of potential implicit bias versus the defendant, who was a young black girl. Do you think that representation matters? I heard you earlier in today's hearing talk about how different perspectives are important. Do you think representation matters?
Yes.
How so?
I think it is very difficult for me, frankly, as a white male, to understand how, using the flip side to a degree, how a female African American comes into my courtroom, looks around the courtroom, and there are sometimes no black people in the crowd.
Mm-hmm.
And
oftentimes.
Often.
And on top of that, this child, I don't know her particular circumstances other than the fact pattern that was shared in the written decision, but on top of that, many of the kids have had no adults that they've ever trusted in their life, period. Right? And so as adults, they're there. Okay, they're adults, but nothing's changed. I think representation matters too. I think you nailed it on the head. That the kids I've worked with, they notice representation, and it impacts their behavior in the courtroom, outside of the courtroom, in the group homes they live in, and are being bounced around, and running away from because they're fearful of gang activity in the group home that they can't be protected from. The state is not protecting them, and they run away and they face negative consequences for running away to protect themselves when no adult has stepped up to protect them. Have you ever been to a state hospital?
Yes,
Have you ever been to a house of corrections?
yes.
How did that inform your work as a district court judge?
When I was a criminal defense lawyer, I went to House of Corrections probably on a weekly basis. I can tell you that I actually went first time as an intern as a district attorney. I will never forget the first time that I heard the clang of the doors close behind me. To realize that anyone who thinks, oh, jail's not a big deal, even a day or two or a week or a month, that's not a big deal. They've never been behind the bars.
I was at Bridgewater State Hospital last week, I was at Bridgewater State Hospital last week, and there's lots of good stuff going on there. And there's some things that need improvement. And I don't know how anyone could make the decision to commit someone there if they haven't been there recently, because it's changed a lot. You said earlier the job is fun, being a judge. I can understand that, and I can tell you're intellectually minded, and that I can see why appeals court would be a fun position. And yet, I've only been here for about 1.5 years. This is the first application that I recall seeing a nominee say that they do not feel the compensation for judges is adequate. For a fun job?
Yeah.
It comes with a pension, right?
Yes.
Okay. So why do you think that, and what is the salary for a district court judge?
Almost 185.
185? What's the median salary in this Commonwealth?
Much lower than that.
Yeah, I don't know what it is. What's the salary for the appeals court?
I have no idea.
Okay. But it's inadequate?
Yes.
Okay. Why do you suppose it's inadequate?
Because in order to attract the best candidates, the best who usually would be lawyers 99% of the time,
Sure.
we need to draw on the best legal minds there are.
Do you mean the best legal minds or the ones who are most concerned with their bank account? Because to me, those are very different things. Because some of the best attorneys I know are CPCS, right? I mean, not all of the best attorneys. Some of them are taking, private work as public defenders.
Absolutely.
They're not doing it for the money.
No.
And to be honest, as much as they might feel good about their work, it's not a fun job sometimes, right?
No.
You know that. You know.
Yep. When I say the best legal minds counsel, I don't mean the ones who get the best paycheck and are necessarily at the big firms.
Can you reconcile that for me? Because I'm hearing you say that in order to attract the best candidates, we need to increase the pay.
Sure.
And so to me, I hear the best candidates, what they're after is the pay. And to be honest, I don't want them on the bench.
No, I don't.
Right? I don't want someone on the bench who's going there for pay
No.
or to pad their pension.
Well,
Right? I mean, do we, as a Commonwealth, is that what we want?
no, that shouldn't be the concern, but
Okay.
what I would
Thank you.
look at are the fact that some of my closest friends on the bench are CPCS and bar advocates.
Sure.
And unfortunately, what I see is after, pick a bunch of years, 5 years, 6 years, they move on because they can't live on the salaries they make. And I think they are some of the best legal minds. And unfortunately, some of them feel they can't go to the bench even though they're qualified. So they don't even consider it because they look at the salary and they say, I can go work at a firm,
Yeah.
I can still do good work,
Sure.
and I can make a lot more money.
I don't begrudge those folks whatsoever. Not the perspective I want to bench. Thank you. Thank you very much.
Senator Hurley.
Yes, thank you. We knew each other when we both were support judges.
We did.
And our relationship was nothing but casual.
Absolutely.
When word started to get out that you were looking I started hearing things about the situation where you held the lawyer in contempt, which would have been criminal contempt, by the way, put him in the docket, where you put him downstairs in the lockup, which, to me, radically changed my attitude about you. I knew you were smart. Yeah, you were cordial, you know, you weren't rude amongst your peers. And so, then I started to get phone calls about you. And the people that called to support you said, and I quote, "Hey, I'm on a committee with him, and he's really, really smart, even though he is obnoxious." All right, direct quote. Well, bells started going off in my head like you wouldn't believe. Because if there's one thing I'm concerned about, I don't care what court it is, every single judge, number one priority, they are people who can get along with anybody, who are patient, who are polite, respectful, not only to people, but about other people's opinions. And that is not what came across with you. Even the people who called supporting you were, yeah, sometimes you can be a little overbearing. Yeah, sometimes you can be arrogant. And I'm glad that we aired the issue about the gentleman that you threw in the hoosgow, because that's important. But everything I heard about the guy before I found out what the total facts were, was that he is a total gentleman and very respectful. So one of the things I'm going to ask you to do is to have him call me, because he didn't call me, because there was no hole in the wall. My concern is that even though you are hearing all this, you are not hearing what the message should be. And that is, you've got to change your expectations. You have to change the way you deal with people. And you have to understand that it doesn't matter who you're dealing with, whether it's the court officer, the janitor, the assistant clerk, or another judge, or a committee member, or somebody on the appeals court. You have to try and rein in whatever it is that you do, that even the people that call in favor of you admit, yeah, he's kind of arrogant or obnoxious, or other terms. And I'm not saying them to be mean or nasty. I'm saying them because I think everybody needs somebody that will point out the defects in your presentation or how you treat people. And in my case, it was my sister. And I always listened to my sister. I was the mayor of Springfield. I had umpteen thousand problems. I laid off 850 people. And I started to get, a little cranky, a little curt with people. And Ellen said, hey, yeah, we know you got problems, and we'll help you deal with them. But you still have to treat people well. And sometimes there's a difference between your opinion of how things should go, because you're so smart, and the reality of life situations. For example, with that attorney. And I'm glad to hear that you reflected on it and you changed it as quickly as you did. And that you expunged the record and did all the right things. But you didn't follow the right procedures. He was entitled to a hearing before you found that. Right? So in that case, you shot in the hip. And I think one of the good things about everybody getting a chance to ask questions is nobody gets to hog the whole time if they're first. And it gives others a chance to listen to different perspectives over a shorter period of time. I want to tell you that you do have friends, all right, who think the world of you. And they called me, and they tried to convince me. And when I said, these are my concerns, well, you know, we all have bad days. No, you're going to the appeals court, you've got to understand that the people who appear in front of you, all right, are there in some very serious situations. And it's not about being the smartest person in the room. It's about coming up with the right answer that's fair and just. So, I also look at your previous applications. In 2006, you wanted to be a judge, and it didn't matter what judge you wanted to be. You didn't say, I applied for district court, I applied for the Boston Municipal Court, and I applied for Superior Court. That's a shotgun. That's not somebody saying, I really think what they do in the district court is great, or I really think that what they do in the Superior Court is great. In 2015, you applied for the appeals court. And I heard rumblings back then, okay, and you never made it through because your due diligence was poor in terms of when they got up here, okay, when they started to really get information from people. That's concerning. Then you applied for the Supreme Judicial Court in 2016, and it was no. Right?
Yes.
So you applied for the appeals court, and things started to rumble. The drum started to beat, mostly negative. And I didn't know about the situation in full, but that was concerning to me. How do you think you are going to be able to change you? Other people don't have to change. You have to change. So that if you don't get 100% of people saying, Andy D'Angelo is a great appeals court judge, if you get 90 or even 80, that's a huge improvement over where you're at right now. How are you going to do that?
Self-reflection. What you have told me today in our phone call was the most difficult thing to hear. I obviously come across that way. Councilor Hurley, I accept everything you say 100% is gospel. That's what people are telling you. I don't think you're high.
I'm
You have
not
no
making it
reason.
up.
You have no reason to. So the fact that people believe that about me is self-reflection that I know I have to change. I have to change in how I come across to people. I have never, I can probably say this, and whether you believe it or not, I don't think I'm the smartest person in the room. In fact, most often, I don't. I just don't. And I question people, I question cases in order to get information, to try to find the right result. And if that, in the way I do it, is what's coming across as obnoxious, opinionated, arrogant, any of the words you use, that is not my intention, but it doesn't matter what my intention is because that's the way it's coming across. So what will I do to try to fix that? A lot of self-reflection, maybe a lot of playing the role of, even if I have an opinion, I quietly keep it to myself at the beginning until I feel I have to say something, but I say it in a way that's collegial. I say it in a way to not be, I hope you didn't hear these words ever, demeaning to anyone. I understand that I need to do a better job, and you have been the one that's pointed that out most, because as I told you on the phone call, what you told me about what my colleagues have said hurts me most of all, and I need to learn from them.
And I certainly didn't do it to be mean or
I know.
spiteful.
I know.
I very rarely, okay, get into any negatives with any of the candidates that come before us. But the appeals court is a place where you can make or break somebody in so many different ways. And it's having to work in 3 judge panels, you gotta get along. You gotta get along to go along, or go along to get along, not necessarily every single time, because you can have an opinion that's different from somebody's. But it may be that you come on too strong, you won't get rid of the bone, all right? You just hold on to it.
I understand. And I will, whether I get through or not, that's something I certainly will improve on, because I don't want that to be who people think I am.
I get it. Thank you.
Thank you.
Thank you, Mr. Chairman. You and I spoke briefly, and I know none of us ever want to be judged by the one bad thing we did in our lives, and we've had a hard day. So tell me about your 16 years of doing good things and what you was proud of. You need a break? I thought it was an easy question.
You are. But the part I like, or the part I enjoy, is helping people. Whether it be the lawyers, or the litigants.
Okay.
And what I'm hearing is, which is hard to answer your question,
Yeah.
is sometimes it's not coming across the right way.
Yeah. All right. I mean, we've all had it. Listen, I was a police chief in my past life, and not everyone loves me. Not everyone in town thinks I was a great police chief, I'm sure. I think they're confused, but this is true. That's the truth. And, all of us have people that like us and people that don't. I do respect Brian D'Andrea there. He called me early on. He actually, was a big proponent of you early on, and spoke wonderful things, and I know other people were stuff I've been with quite a couple of times in my career as a lawyer. But, you do have a great resume, which we haven't talked about a lot. You tried murder cases, you were in the Suffolk DA's office, you were an adjunct professor, bringing your knowledge to law school for like 13 or 14 years. So I do appreciate all your service and all the good things you've done, and I appreciate the humility to come in and say, yeah, I did some work that one day, and too bad that we spent 2 hours talking about that one girl. That wasn't a little incident, it was a big incident, but too bad that I just want to highlight some of the good things you've done with 16 years of church, and I appreciate that.
Thank you so much. It means a lot.
That's all I have. Thank you.
Okay, thank you. How old are you?
53.
You were district court judge 16 years, and that is what, 43, 37?
We're scheduled from Montana Bay, bro. It's good.
Young age, you judge,
Was.
Yeah, I want to have it.
but yet, you weren't on a year, you wanted to go to BMC. No?
No. I applied my first time to the BMC, the district court, or the superior.
Could he work for
Okay,
5
so the
weeks?
first 3 tries, the same year you applied for
Then he
all
came
3.
to work?
It was on one application.
And did you think that you were qualified for the Superior Court?
I think, yes.
And you applied for the appeals court twice, and the SJC in 2016,
That's correct.
7 years ago, so you would have been 146?
Yes.
You thought you were qualified for the Supreme Judicial Court, 46?
Yes.
You said to Councilor DiPaolo that you think judges should get more money because the money that they're given now doesn't attract good talent, right?
Sometimes.
Okay. But you're here,
Yes.
so should we assume that you're not good talent?
No.
So your argument got a hole in it right there with you, right?
With isolated examples, yes.
So you get $185,000 a year, you get a wonderful health care, right?
Yes.
And you get a spectacular pension that most people in this state will never, ever see. right?
Yes,
So when you retire, if you live on a pension for 10 years, let's say, by the time you retire, your pension is probably going to be somewhere around the area of $200,000 a year. Guess, right?
could be.
For waking up in the morning, you're going to get $200,000 a year when the average, that's probably in the top 10% of what people make in this county.
Yes,
I'm going to suggest to you, and I have no problem with what judges get for salary. If the salary was reduced tomorrow to $125,000, you would have still applied for this position, wouldn't you?
yes,
And I'll bet you if we opened it up and said, whatever lawyer wants to be a judge, you can come into the State House and get an application and get in the line. That line would extend right out the door of the State House down Beacon Street. Because just about every lawyer I know wants to be a judge. Good, bad, and whatever. So I'm a little bit concerned you don't think it's enough money. It is fabulous money. Fabulous. In order for you to make that much money as a lawyer that you're getting right now, you would have to make in the area of $360,000 a year. Correct?
yes, with benefits.
And you don't think it's enough money?
I said that I don't think it sometimes attracts the best candidate.
Well, I don't think it has anything to do with money, whether you're good, bad, or different. I know wonderful judges, I know good judges, I know okay judges, and I know lousy judges. So, yeah. I'm going to ask you some questions, and I want a yes or no answer.
Yes, sir.
You go on the appeals court, so the appeals court has the ability to change law, or at least try to change law. You believe in same-sex marriage, yes or no?
Yes,
Death penalty, yes or no?
no,
Woman's right to choose, yes or no?
yes.
Give me your definition of empathy.
Caring about what's before you and putting yourself in the position of the person that's before you.
Definition is sympathy.
Being sad or cognizant of the person in front of you, how they got there, why they got there, and to try to help them.
Compassion.
Again, similar to the last answer, but again, making sure you can try to put yourself or understand the position that that person is in and why.
Arrogance.
Coming across as being the smartest person in the room.
I too received a lot of calls for and against you. And I was on the council when you tried to go to the appeals court in 2015. And I was told that you were at a conference in Williamstown. And you sat at a table and you said to the judges sitting at that table that that would be your last Williamstown event. And because you were going to the appeals court. Did you say that?
I did not.
Okay, now I want to tell you something. I've heard that from 3 people that were at that table. And I know that I respect them, they're a good judge. They weren't mean about it. They weren't mean about that to me. But you're saying that they've all told me something that wasn't true.
No, what I'm saying is that, and I remember the position and who else was being considered for the appeals court, and what was said was, I had met with the governor's legal counsel, and I was hopeful that I would be going to the appeals court at that time with one of my colleagues. I never once, ever said that I was going to get through because I knew I had not gotten through.
Okay.
Positive.
You know why you didn't get through?
Well, from what I'm hearing, it's probably because of due diligence.
It was because you locked that lawyer up. Because your name was floated around the councilors here. And I know what they said to the governor's lawyer. You know what I said? tell me why you said, I'm a little, I don't understand your answer. Why did you say legally appropriate?
After the incident happened, it was looked at, again, I can't remember whether it was Judge Dolly's office.
No. Why did you say it today?
Yes, because when it was looked at by other people, I was told that the way I acted was legally appropriate.
Who told you that?
The Chief District Court.
Well, you
And
didn't follow the law,
I,
did you? Yes or no? Did you follow the law in contempt?
I believe I did. I gave the lawyer an opportunity for a hearing. He chose not to have one. I asked him if he wanted to go up.
Whoa. It's my understanding, and I could be wrong. You're gonna find somebody in contempt, you have a hearing to determine whether or not they're in contempt before you punish, right?
That would be criminal contempt. This was contempt to try to enforce a court order of getting him to go to trial.
Whoa.
And if I'm wrong about the law on that, I
Excuse me.
will stand
Excuse
corrected.
me.
This was not punishment, counsel.
There are both civil and criminal contempt, isn't there?
Yes, sir.
What other kinds of contempt are there?
There's those two, civil or criminal.
So this wasn't civil,
No, in my,
yes or no? Was
Yeah.
it civil?
I thought it was. In the context of a criminal case, it was civil contempt because my,
Okay, so civil contempt, and I may be wrong on this, but civil contempt is a lesser contempt, is it not?
well, it's a lesser procedural
Right.
thing.
But you don't have a right to lock up somebody before you have a civil contempt hearing, do you?
Correct.
So
Correct.
this wasn't civil, you locked them up first.
I had a hearing with the lawyer. He and I,
No.
that was the hearing. I gave him an opportunity. I said to him, would you like to seek a continuance to go out and have a lawyer come in? Would you like, and I knew, and I asked Macdel, would you like to have the hearing now?
Okay,
And he said, I'm not going to trial. I'm ready to tell you why now.
okay. So, let me just get this straight. Now, you said to him, he filed a motion to withdraw, and you denied that motion,
After, yes. Yes.
right?
Yes.
Did you ask him why he was filing?
Initially, yes. And repeatedly, yes.
Okay, he told you.
Yes, sir.
You were concerned about getting this case resolved. That was in your mind. You told us
Yes,
that, right?
yes, of all the
We've
parties.
been there a long
All
time.
the parties being
Counselor
heard.
Kennedy said, what difference does a month make? And you said, well, it's been around a long time. It affected both parties, right?
Correct,
Okay. So he files a motion to withdraw.
yes,
You deny it.
yes.
What did he do then?
After I denied it,
Yeah.
I said, counsel, are you prepared to go to trial?
Okay.
He said, am I prepared? Yes. I said, so we can go to trial? No, I am not going to trial today.
Okay.
And I said,
Okay.
counsel, why?
Okay.
And he said, even though she says that she is now content with me being a lawyer,
Yeah, I get that.
and I'm
So he
paraphrasing.
explained. Okay.
He
So what
explained.
did you do after he explained it again?
He said, counsel, I've heard your objection.
Yeah.
I'm overruling the matter, and I am ordering you to go to trial.
What did he say?
I refuse to go to trial.
What did you say?
Counsel, if you keep refusing to go to trial, and this went on a few times before I said
Okay, I
this,
get it.
but I said, if you refuse to go to trial, I am going to have no option, in my opinion, but to hold you in contempt.
Okay.
Do you
This was
understand?
this
do you
was
understand
somebody
that?
that you said was friendly. You and him were
Yeah,
friends.
yes, please.
Okay.
At no time was there
Well,
disrespect or
What-
yelling
what
at
I-
me.
what-
Yeah.
If I'm friendly with a judge and he's doing the big what you're doing to me, I don't think you're being friendly to me. But in any event, okay, so you said to him, look, if you keep denying, if you keep refusing to try the case, I'm going to have to hold you in contempt.
Yes.
What's he say?
I said to him, do you want to call Macdel or a
Yeah.
lawyer to see about representation
Well,
for him.
you haven't had him in contempt yet, have you?
No, and that's what I said. Do you want to have a lawyer come in and represent you so you understand that you're deliberately, potentially violating a court order? The answer was, I don't need to speak to someone.
Okay.
We can have the hearing right now. I said, okay.
Okay.
Counsel, you understand, I've heard your objections.
Yeah.
I've denied your motion to continue. All the parties are ready for trial. You told me that you're legally ready to go to trial, and the only reason why you are not going to trial is because you're concerned that she might report you.
Right.
Answer, yes, that's correct. Counsel, I am ordering you to go to trial. I do not believe that there are legally sufficient reasons for you to withdraw.
Okay. What's he say to that?
No matter what you say, Judge, I am refusing to go to trial today.
Okay, what do you say then?
I say probably one last time to him.
Okay, one last time.
Yeah.
Get to the point where you say you're in
I
contempt.
say-
What do you say?
I say, if you don't follow my order right now, you're going to be held in contempt and placed in custody. Do you understand that? In order for me to see if you will comply with my court order.
Okay.
I understand, Judge.
Okay, what do you do?
Mr. Court Officer, take Mr. Gerard into custody.
Okay.
Please give him his cell phone so we can call any lawyer to see if he wants to change his mind.
Okay. Does the courthouse put handcuffs on him?
I don't know.
Where's he taken?
There is, in the Worcester District Court, in this courtroom, there is a dock behind the court door. I'm assuming, Counselor Jubinville, that cuffs were put on him.
Okay.
I
He's
assume.
put in the dock?
Yes. He went behind the door. Again, I'm assuming he was placed into the cell alone in that dock. I'm assuming.
What do you do then?
I said I'm going to take a recess. I'll see if Attorney Gerard will change his mind and go to trial. I then go into my office. I close my door.
Who do you call?
No one. I thought about it. Again, as I said, I remember it like it was yesterday, putting my hands in my head and saying, I can't believe this just happened. I can't do this. I don't care why I'm not doing this. I'm going to go back out and I'm going to expunge the contempt. And that is where Counselor Jubinville, frankly, I don't know whether I had the legal justification or authority to do it, but I was going to do it because I did not want this on his record.
One thing that bothers me, you made a point of saying to Counselor Kennedy, this case has been around, we've got to get it going. Your two choices are to give a continuance or to lock the lawyer up. And in any case, any decision, that trial is going to be put off. Correct?
No, I was, and maybe this is...
No.
No, that was not my, I did not think it was going to need a continuance. I
Okay,
thought he would ultimately
But when
comply.
you finally made the decision about the contempt, you knew that you were not then going to be able to try that case.
No,
No?
at least in my mind, and this is where...
Well,
I thought if I held him in contempt even briefly,
he would come out,
he would
try
come
the
out,
case.
he would come out and say, I will go to trial. And maybe, and not maybe, this is where I didn't think it through when I held him in contempt, but that was my thinking, that if I gave
The
it,
case ultimately was continued.
it was with a new lawyer appointed. I got a new lawyer for the defendant.
So all of the contempt stuff was really unnecessary.
As it turns out, and ultimately, absolutely, 100%.
All of it.
Yes, sir.
And to use a lockup with handcuffs to get a lawyer to come in and now try the case, how is he ever going to do that? Walking out in a courtroom after he's been hauled off in cuffs, he's now going to sit with a client and try a case in front of you? You'd have to recuse yourself, wouldn't you?
Yes.
Probably.
Probably. There's no problem about it. You just put the guy in cuffs in a jail cell.
And that is why, as soon as I went into my office, I realized I had to reverse it because I knew, A, it was wrong, I didn't want to do this to John, and B, it wasn't going to accomplish what I thought it was going to accomplish. I was wrong. I acted in the moment and I did something wrong. I did.
If I was you and I had done that, I would look and say, I've ruined my relationship with this fellow, that it was a good one. I got nothing out of it, because the case got continued anyway. Now look, I know people make mistakes. I've made hundreds of them in my life. But you've been around the court system, and you knew, you had to know, that that third rail should never be touched. You've heard stories about it.
Of course.
I heard that you went in, you had him in your lobby, and there was some sort of an apology, and that he wasn't happy about it after the way you put it. That's what I heard from people in Worcester that spoke to him after he came out of your lobby. But,
Okay.
okay, but. I want you to, if you would, apologize today in public to this lawyer by name.
Absolutely. Attorney Gerard, I am sorry for what I did. It was wrong. I should never have done it. If I could somehow magically go back in time and change what I did, I would. It will never, ever happen again. And I will do everything I could in my power to make sure that this does not tarnish your reputation in the future. And I've done that since, and I will continue to do it every day.
I did get some calls on your behalf. Tony Salerno, World, and of course Peter Ettenberg and Jeff Despacopoulos. Good recommendation, standing in the event. So anyway, that's it.
Thank you.
Joe, real quick.
Yes, sir.
Thank you, darling.